calling you and asking you and have you say, well, it's in the beneficiary declaration. And then you say, but you don't have that document. How would she know? How does she go about finding out that information?
Object to the form.
It's not a funding matter. Do you know what I'm saying? I mean, she has real concern about the information there which says Freddie Mac owns your loan. Sendlar is the servicer. Sendlar is the creditor to whom the debt is owed. And she doesn't really know, as you sit here, you don't know either. What is the difference between an actual holder versus a holder? And so the question I'm posing to you is not to be comical.
I'm not trying to be comical.
And the question is one of fact. It's not a legal conclusion. It's not for you to analyze. It's simply, if I want to know who holds my note amongst all these entities that are named in the notice of default, how do I do it?
Object to the form.
I don't know how to answer your question.
Do you don't know how to answer, or you don't have an answer at all?
Both.
So is it fair to say that within your company there isn't?
But we're coming back on record now. The time is 12:54 p.m. Yes.
I want to go back and discuss the best practice policy that we had discussed earlier with you.
Can you stop for just a moment?
Okay. Can I have this one? Yeah. 17. You've been handed Exhibit 17, Ms. McElligott. Do you recognize Exhibit 17?
Yes.
Tell us what it is.
It's an assignment of deed of trust.
And do you see your name there as the signatory?
Yes.
Okay, and who did you sign on behalf of on Exhibit 17?
Vice President on behalf of members.
What is the date of Exhibit 17?
January 5th of '09.
All right. I want you to tell me whether this is, if this exhibit represents a template that was being used by NWTS Trustee.
It does appear to be.
Right. And in the body of the assignment here, and this is the assignment of deed of trust, am I correct?
Yes.
On a particular property of Santos and Doracelis, correct?
Yes.
Right. So let me focus you on the sentence, which is the last sentence of the assignment, starting with together with note or notes. Do you see that?
Yes.
Would you please read that whole sentence?
Together with note or notes therein described or reference to the money due and to become due thereon with interest and all rights accrued or to accrue under said deed of trust.
Okay. So you sign this exhibit on behalf of MERS to transfer interest held by MERS to another entity, correct?
Object to the form.
To put a public record.
Of what?
The assignment out of MERS into Wells Fargo Bank.
So that sentence that you just read, together with note or notes, what does that mean?
I don't know.
You don't know why that matters?
This document is 5 years old. I don't have any comment on it.
So it says what it says. And you don't deny that that's one of the documents that was recorded in public records back in your company?
No, I don't deny that.
You don't have any comments as in, do you know for a fact at any time in signing on behalf of MERS, yourself, that there was note or notes transfer from MERS to another entity?
I don't know.
Object to the form.
What do you mean you don't know?
I don't know the answer to your question.
And why wouldn't you have an answer? You signed here under notary, you know, and your signature and your statements are notarized.
You asked me if I had knowledge. I don't have knowledge.
Okay, so what knowledge, if any, that you had at the time you executed this particular document, the assignment to the trust on behalf of MERS?
I do not specifically know from 5 years ago.
If you don't, by that statement, do you not remember, or that you didn't have any knowledge of whether MERS had any notes that were being transferred?
Both.
So you don't know for a fact that MERS had any notes that would have been transferred by virtue of this assignment?
Object to the form.
I have no knowledge.
Do you recall during that period of time why you were signing as a vice president for MERS?
No, I do not.
Then you have it 18. Tell me what 18 is.
An appointment of successor trustee.
What is the date of this appointment?
December 31st of '08.
Does it represent one of the templates or forms that your firm prepared and sent out? Or not sent out, but recorded in the public records?
Yes.
And can you tell me if 18 relates to 17 in the sense that it involves the same borrowers and property?
Yes.
And do you agree, by looking at the dates of 17 and 18, do you see that?
Mm-hmm.
That they are, one was executed in '08 and the other one was executed in '09.
Yes.
So the appointment was executed in '08, but the assignment did not get signed until January 5th of '09.
That's correct.
And what is the order of the recording of these two documents, Ms. McElligott?
The assignment recorded before the appointment,
On what date?
January 9th of '09.
And does that relate to the best practice we testified to earlier?
Object to the form.
As in the documents being recorded in the correct order?
Object to the form.
It does appear so.
Refer you to Exhibit 19. Take a look and tell me if you recognize 19.
Yes.
What is 19?
No, it's the trustee's set.
Relating to the same property that we were talking about in 17 and 18?
Yes.
I'm going to ask you to look at the first page of Exhibit 19 and ask you to refer to that paragraph that starts with a sentence that begins with which is subject to that certain deed. Do you see that paragraph?
Yes.
And in here, in this paragraph, first of all, who signed Exhibit 19?
I did.
And you cite as Vonnie McElligott as opposed to your legal name of Yvonne McElligott, is that right?
Yes, I
Object
did.
to the form.
And can you tell me why that is?
I would say that most of the documents I signed were signed under Vonnie McElligott.
And my question is why?
Because that is what I signed under, and that's, except for one time, that is the name that's on the documents that allow me as an authorized signature.
So Vonnie McElligott is the name that your company resolved for you to sign documents. Is that what you're testifying? correct?
except for one time.
One single occasion?
Yeah.
Object to the form.
One time, okay, one time as in one single occasion where you sign as Yvonne?
No, the one single occasion when you produced a document that showed that the articles showed me as signing as Yvonne.
Oh, okay, so you're relying on that article.
Object to the form.
Is that what you're saying? I don't understand your answer. Is that, are you referencing the fact that you sign as Vonnie McElligott as opposed to your legal name, Yvonne McElligott? Because there's a document out there that authorizes you to sign as Vonnie as opposed to Yvonne.
Object to the form.
I don't even know where your question went. I'm sorry.
I asked you why you sign your name here in this exhibit as Vonnie, and your answer, while you also testify that your legal name is Yvonne.
Right.
And my question to you is, why did you sign your name not as your legal name, but Vonnie McElligott?
I sign everything as Vonnie McElligott except for very, very few documents that are personal.
And my question then is why?
That's my name.
As my references to your legal name.
I don't sign using my legal name.
Okay. And you don't have a reason for that?
I don't.
In the paragraph that I was referring you to earlier, can you tell me that according to the paragraph I directed to you to, who the beneficiary being identified in this notice of trustee sales?
In this paragraph, it recites who is listed on the deed of trust.
And who is that?
Mortgage Electronic System, the registration system.
Does that make logical sense that because Mortgage Electronic Registration System, Inc. appeared to be the original or the beneficiary in the deed of trust that you executed the assigned, strike that. Okay. Let me ask you a different question. This reference to the original deed of trust in this paragraph also is followed by a reference of the assignment by MERS to Wells Fargo, does it not?
Yes, it does.
And according to this notice of trustee sales, the property was going to be sold on what date?
January 29th of 2010.
You've been handed exhibit 19,
No.
20?
Yes.
Do you recognize 20?
Yes.
What is it?
It's a trustee's deed.
Relating to the same property that we're discussing,
Yes.
of the Silas?
Yes.
Silas? Okay. By looking at this exhibit 20, the trustee's deed, can you tell me if the property was successfully sold at auction? Or that was successfully foreclosed, I should say.
It would appear so by the deed.
And who is the deed in favor of?
Object to the form.
Federal Home Loan, well, in favor of.
Federal Home Loan Mortgage Corporation?
Well, what do you mean by in favor of?
Who is the person that got the property?
Federal Home Loan Mortgage Corporation.
Okay. By looking at the trustee deed, can you explain why the trustee deed was made in favor of Federal Home Loan Mortgage Corporation, while the other documents referring nothing about that entity?
Object to the form.
Is there a copy of the notice of default in front of us?
I don't have that. I'm just asking you, these are
And I-
recorded documents.
I can't agree that it's not referenced somewhere else.
But by virtue of the trustee's deed here, did Federal Home Loan Mortgage Corporation show up at the sales
No.
and made a bid?
Object to the form.
I said no.
Would that be true as to your earlier testimony that the Federal Home Loan Mortgage Corporation doesn't show up at the sale?
Object to the form.
But you are given a bid on behalf of the entity.
Object to the form.
I received bidding instructions.
And would you have received the information from the Federal Home Loan Mortgage Corporation or from some other entity?
I have no way of knowing how the information was provided.
But typically, in your work of handling Freddie Mac's portfolio loans, how does it work?
What is it?
Does the entity, the GSE, show up at the sale and submit a bid?
I don't understand the question. We've just established that they don't show up at the sale.
Okay. Do they ever, or is that a standard practice?
I have no way to know if they ever show up at a sale.
In your experience, have they ever?
I don't attend the sales.
I'm asking you to look at Exhibit 21. And do you know what it is?
It's an assignment of deed of trust.
What is the recording date?
August 13th of '09.
And what is the signing date?
August 5th of '09.
You're now looking at 22. And I will call your attention to, if you're looking at 22, the auditor's file being referenced there. Instrument entry, document number, do you see that?
Yes.
2008, ending in 0995?
Yes.
Okay. And then I'm going to refer you back to Exhibit 21 and ask you whether 21 also refers to that particular auditor's file document.
Yes.
And what is the recording date of Exhibit 22?
June 29th, 2010.
Sorry, the recording date?
June 29th of 2010.
Okay, so 22 was recorded about a year after 21, would you agree?
Yes.
Can we go off the record for a second?
Yes.
Record reflected as 1:12 PM, we're off the record. Reflected as 1:14 and we're back on the record.
I apologize for the confusion. So, in looking at 22, my question to you was whether 21 and 22 referring to the same property or the deed of trust under auditor number 2008, ending with 0995.
Yes.
Would you agree that Exhibit 22 was recorded June 29, 2010, the year after Exhibit 21, right? You're now been handed 23. Do you see that?
Yes.
Can you confirm for me if 23, which is another assignment of deed of trust, refers to the same deed of trust by looking at the auditor's number there?
Yes, I do know.
Okay. And what is the recording date for Exhibit 23?
August 16th, 2010.
So then would you agree that 23 was recorded after 22?
Yes.
You're now looking at 24. Does 24 refers to the same deed of trust of the prior exhibits?
Yes.
Do you recognize 24?
Yes.
What is 24 represent?
Object to the form.
What is it?
It's an appointment of successor trustee.
Appointing whom to be successor trustee?
Northwest Trustee Services, Inc.
And what is the date of Exhibit 24?
September 22nd of 09.
And what is the recording date of 24?
August 16th of 2010.
Do you have any idea why Exhibit 24 would be recorded nearly a year after it was executed?
No, I do not.
Okay. And do you recall your testimony that the assignment, the recording of the assignment is not necessary for your work as trustee? Do you recall that testimony?
I do.
And so in looking at this series of exhibits from 21 through 24, can we conclude that you did rely on the previous assignments to get to the appointment of successor trustee?
Object to the form.
Not necessarily.
Not necessarily? Okay. So what is the rationale for recording the appointment of successor trustee nearly a year after it was executed?
Object to the form.
I think I already answered that.
What was your answer?
I don't have any.
When you look at 24, does it tell you that the recording was done at the behest of Northwest Trustee?
It doesn't tell me that, no.
It doesn't tell you that, but the appointment in fact conferred authority on Northwest Trustee to act as successor trustee, does it not?
Yes.
Okay. So is it your testimony that Northwest did not rely at all on this appointment of successor trustee as recorded in the public records?
Object to the form.
Why would I didn't say we didn't rely on it, and I'm not sure I understand your question.
Did Northwest rely on this Exhibit 24 for its authority as successor trustee in this particular property and foreclosure?
I have no way of knowing.
What do you mean you have no
Well,
idea?
you've only provided me this documents. I don't know anything about this file.
I'm not asking you in terms of this file. I'm asking you whether your company would rely on an appointment of successor trustee for its authority to foreclose.
Object to the form.
Does it need an appointment of successor trustee in order to foreclose?
Which we already covered earlier. Yes, we do need an appointment of successor trustee in order to foreclose.
Right. And in looking at this Exhibit 24, which you acknowledge to be one of the documents that was recorded to allow your company to foreclose on this property, you have no idea why it was recorded,
Object to the form.
right? Is that your testimony?
Object to the form.
That's not my testimony.
What is your testimony? Why was it
What is your
recorded?
question?
Why was Exhibit 24 recorded in the public records? To the best of your
I have no way of knowing without more information on my file.
You're at 25? You're at 25 and tell me what it is.
Notice of trustee sale.
Relating to what property? Same property we've been talking about?
Yes, it is.
Do you recognize Exhibit 25 to be a document that your team would have been responsible for?
Yes.
Do you recognize your signature there to be the person who signed Exhibit 25?
Yes.
Okay. And what is the purpose of Exhibit 25 when you executed it?
Object to the form.
Answer if you can.
I'm not sure I understand your question.
Why did you execute Exhibit 25?
Because we were setting the sale on the property.
That's the same property that you were talking earlier relating to the appointment of successor trustee, is it not?
It is.
Okay, so now that you have a chance to look at 25, I'm going to ask you the question again. By virtue of looking at 25, can you say for a fact that Northwest Trustee rely on the appointment of successor trustee in the previous exhibit to foreclose on this property?
Object to the form.
I'm sorry, I still don't understand your question.
Is 25 related to the appointment of successor trustee in 24?
Yes.
You're now given 26. And I'd like for you to take a look at 26 and tell me what it is
Trustee's deed.
relating to what property.
The same property we've been discussing on the last few exhibits.
So by looking at 26, can I conclude that this property was sold or successfully foreclosed?
Object to the form.
An assumption can be made by the recording of the document.
Which is, it was successfully foreclosed.
Correct.
Let me put that away. Take a look at 27, Ms. McElligott, and tell me whether you recognize 27.
It is an appointment of successor trustee.
Allowing Northwest Trustee to foreclose, is that correct?
Can we go off the record? I think the wrong document. What do you have? I have an assignment.
Sorry about that. No, that's okay. You have your backup. Do you remember my question?
Not precisely.
Okay. In looking at 27, you testified that it is an appointment of successor trustee, and my question to you is, does this document allow Northwest trustee to foreclose on the property being referenced here?
Object to the form.
It is required that we be appointed the trustee in order to process the foreclosure.
What is the date of signing?
8/13/12,
What is the date of recording?
8/28/12.
Now looking at 28, and I see that you're looking at 27 and 28 side by side. What is 28?
An appointment, or I'm sorry, an assignment of deed of trust.
And what was the execution date?
8/23/12.
And what is, so would you agree that the assignment in this case, Exhibit 28, referencing the same property, was executed well after the appointment of successor trustee, which is Exhibit 27?
Object to the form.
It was executed 10 days after.
What is the recording date for both of these exhibits?
August 28th of 2012.
And how about the time?
3:34 and 46 seconds p.m.
So in looking at the recording order, this reflects the best practice you testified to earlier.
Object to the form.
The assignment recorded before the appointment.
What I will do is I will have these two marked. So I'm asking you to look at a pair of assignment and appointment again, Ms. McElligott. Do you recognize these to be the product of your companies, as in the template form?
Yes, it is our template.
All right, and it refers to the property owned by the Anderson, or Alan Anderson, is that correct?
Correct.
And I'm just going to ask you to confirm for me quickly that the assignment in this case was executed after the appointment,
Correct.
and yet they were recorded on the same date at the same time,
One after the other.
in the best practice order. Is that correct?
Yes.
So the assignment goes before the appointment.
Okay, so the appointment is marked as 29 and the assignment is 30, is that correct?
Yes. Missing the assignment.
Number 38?
I don't know if you can find it. Come back to that later. What is the name? Right? No. Appointments? That's right. Let me skip that. Okay. In your review of this file, Ms. McElligott, sure, I have something else. You've been handed Exhibit 31. Does it look familiar to you?
Yes,
What is 31?
an appointment of successor trustee.
For Northwest, your company to act as successor trustee, correct?
Yes.
And who signed this appointment?
Carrie Ehringer,
What's her title?
first VP,
And who did she sign on behalf of?
MERS.
Okay. Do you recall, strike that. If we were to look at 31 for what it says in there, strike that. Let me ask you this question. Does 31 represent a template or a form prepared by Northwest?
Yes.
Okay. And what is the date of this exhibit?
September 10th of 2008.
And it has your name on it as being returned to you after recording, correct?
It does.
And in this particular case, Mortgage Electronic Registration System, Inc. was the beneficiary that appointed you directly, correct?
It appears so.
It would be difficult for you to look at just Exhibit 31 to know the circumstances of this particular foreclosure sale.
Yes, it would.
This is 32. 32 look familiar to you?
Yes, it's a notice of trustee sale.
Relating to the property being described in the appointment of successor trustee, Exhibit 31?
Yes.
But by looking at that particular document, does it give you any help to remember the circumstances of this particular file?
Absolutely not.
Let me just ask you to refer to the first page of Exhibit 31. I'm sorry, 32. And I will direct your attention to 1, 2, 3. The third paragraph, starting out with which is subject to that certain deed of trust. Do you see that?
Yes.
All right. And can you refer to the sentence after the comma, to secure an obligation or obligation in favor of Mortgage Electronic Registration System, Inc., MERS, as you see that? Do you see that?
Yes, I can see that.
All right. So does that language tells us that the beneficiary in this case was MERS?
Object to the form.
Have you represented in this exhibit? And by the various assertions in Exhibit 32, is it safe for me to assume that MERS was the one that referred the foreclosure to Northwest Trustee?
Object to the form.
I don't think you have safety in that.
Okay. Where else can I find in this document to assure myself of that fact?
Object to the form.
Take a look.
I don't think you can.
How about going back to 31?
These documents don't give that information to you.
So in looking at 31 and 32, we cannot tell whether MERS was the one that initiated or sent the referral to Northwest Trustee.
No, you cannot.
You're now looking at 33, which I will represent to you that is the trustee's deed for the same property that relates to 32 and 31.
Yes.
Do you agree? So in looking at 33, it says here that Northwest Trustee Services grants, conveys the property to Federal Home Loan Mortgage Corporation as grantee. Do you see that?
Yes, I do see that.
And that doesn't, you go down to the body of the trustee's deed. Paragraph number 5. Do you see that?
Yes, I see that.
Does it clue you in terms of who made the referral to foreclose on this property?
I don't think cluing me in is proper.
So what is the significance of the disclosure there with Countrywide Home Loan Servicing LP?
I don't specifically know the significance of paragraph 5.
You have no opinion whatsoever.
I don't have an opinion.
Is there, in your review of this file, do you recall whether this property or the borrower was referred to mediation?
I believe so, yes.
What understanding or working knowledge do you have about the process of mediation in the state of Washington?
Object to the form.
I am completely not involved in the mediation process.
What is your understanding in terms of the significance of someone being referred to mediation while they're in the middle of your foreclosure?
What do you mean by the significance?
So if the borrower goes to mediation, what does it do to your foreclosure?
My foreclosure file was on hold.
And who authorized you to put the file on hold?
Object to the form.
It's a requirement that we not proceed to set sale while it's in mediation.
Who typically informs you of the fact that a property or borrower has been referred to mediation?
We get notifications from the Department of Commerce, I believe.
You're looking at 34. Does it help you at all in terms of your recollection about Ms. Lucero being referred to mediation?
Well, I had recollected that that was the case.
Do you recognize 34?
I don't specifically recognize having looked at this particular referral.
In your review of the file, do you recall when you were notified of her mediation?
No, I do not recall a specific date.
What is the date of Exhibit 34, if you can tell me?
September 3rd, 2012.
Does it refresh your memory at all as to when you learned of her mediation?
It does not refresh my memory as to when I was notified of the mediation referral.
You're looking at 35. Do you recognize 35 at all as something that was within your foreclosure file?
No, I do not.
The date of Exhibit 35, as I would represent to you, is October 12, 2012. Does that date remind you or refresh your recollection as to when you were notified?
No, it does not.
You're looking at 36. Ms. McElligott, do you recognize 36?
It is a reinstatement quote that is generated by Northwest Trustee Services.
And this is part of the Lucero foreclosure file, is it not?
Object to the form.
It is identified as such on this document.
All right. And if you could look at the first paragraph right below the greetings, what said, this letter responds to your request for reinstatement figures good through November 7, 2012. You see that?
Yes, I do.
My client had never asked for a letter to contain reinstatement figures. Do you know why this letter was generated?
I have to make an assumption that we were asked to produce reinstatement figures for the purpose of the documentation needed for mediation.
And who would ask you to do that normally?
The mediation counsel,
And in this case, would be RCO?
as far as I know.
But the exhibit 36 actually was sent out to my client. Is that not true?
I do not know if that is true or not.
But if this letter is addressed to my client or reference my client's name, is it safe to assume that it was sent to my client?
Object to the form.
I don't think you can make that assumption if it was created for mediation purposes.
If it was created for mediation purposes, do you know for a fact, or are you just surmising again?
I'm surmising.
Okay. So neither one of us know for sure whether this letter was sent to my client, even though it was generated for purpose of RCO's request.
Object to the form.
I don't think we surmised anything.
Well, what I'm trying to ask you is that if I represent to you that my client never asked for it,
Right.
and your testimony is that we normally, give it to RCO because they request it. Is that
Object to
correct?
the form.
I said I made an assumption that that is why this would have been generated if your client did not request it.
You're assuming based on what?
On what you're showing me.
This is the first time you've seen a letter like this?
No, I've seen reinstatement letters many times.
Okay. This particular reinstatement letter, you don't know for a fact that it was requested by my client or RCO.
Object to the form.
Is that correct?
Repeat your question?
Do you know who requested the reinstatement figures as indicated in this Exhibit 36?
No, not as indicated in this exhibit.
But would it be the case where Northwest just sent a letter out to my client and she didn't in fact request the
For no
reinstatement?
reason and no.
So if she got it and did not request it, you would not know why.
Correct.
I want to go back to your testimony about receiving training every so often due to changes in the law. Who provided the trainings to you in the past and up to the most recent one that you just talked about?
Object to the form.
I honestly don't recall.
You don't know who
I don't
gave you the
recall.
training? You don't recall?
I don't.
And you testified to one that was just recent for the upcoming June changes,
Yes,
correct?
that was a meeting with Alan Burton and Jeff Stemmen.
And you have, in the trainings that you testified to, was it on-site, was it off-site?
On site.
And do you remember the locations where you went to receive the trainings? Any one of them?
Our conference room.
You said off-site in your conference room,
No, on site.
on-site. Were they all on-site?
as I recall.
Are you aware of the concept that the trustee has to act in good faith?
Object to the form.
Yes.
What is your working knowledge or understanding of what good faith means?
Object to the form.
Give a duty to both parties to be fair and objective.
What are the specific duties?
Object to the
I
form.
don't understand your question.
You said to be fair and objective, relating to what specific tasks?
We're talking about the foreclosure and the foreclosure process.
So give me an example of what specific activities or programs or things that Northwest provides to the borrower as evidence of good faith.
Object to the form.
I don't understand the question. Programs.
Is there a program in Northwest Trustee that enables a borrower to communicate with Northwest and determine the contents or the information contained within the notices that they receive?
I don't understand what you mean by program.
Is there a dedicated phone line for them to call in?
There's phone numbers and we all have phones
So when
that can be reached.
So when a person called, do you recall one instant where you received a phone call from the borrower saying, I don't understand the contents of the notice of default that you sent me? Do you recall?
Well, honestly, nobody ever says that, but, so I think you need to be more specific.
Have you ever received a phone call from a borrower
Of course.
concerning her lack of understanding of what Northwest indicated in the notice of default?
Object to the form.
Yeah, I would need you to be more specific. I mean,
Anything that is contained in that notice of default.
sure, people call about anything contained in the notice of default.
When did you do that, when you get that phone call?
You need to be specific in regards to what part of it.
Well, just tell me one instant where you had a phone call as such, and tell me about that phone call.
Usually people call about the time frame, so we give them the timeline. That's usually what they're most concerned about.
As in when my house is going to go for sales, correct?
Correct.
Any other concerns that you have come across? Not at all?
Well, of course. I mean, but there's hundreds of different examples. I don't understand what you're.
What happens when a borrower calls you and says to you, I want to know who owns my loan?
The owner of the notes listed on the notice of default.
And that would be your answer to that, right?
I would refer them to the notice of default.
How about if they call you and they say, I want to know who holds my note?
Normally, no debtor calls and asks those types of questions.
Just hypothetically, if they do, what would you do?
Object to the form.
Where would you send them?
I don't really have an answer for that since I haven't had that question before.
But if it comes up, who would you send them to?
We refer.
Object to the form.
I don't know that I would send them. I mean, we will always suggest that people gain their own counsel.
Okay, so if if a borrower calls you and says to you, I want to know who holds my note, you're going to say, go get a lawyer? I mean, I'm trying to understand. It's not at all impossible that someone would call, not you personally, but someone in Northwest.
I don't know. I can't speak for anybody else in Northwest
And
Trustee.
I'm giving you that hypothetical so that you can tell me where you would direct this person or tell them what to do.
Object to the form.
What, you would give them any recommendations at all?
I just told you one of the recommendations that we would give.
Is for them to get their own attorney.
If they have questions that are legal questions, yes.
Okay. Why would it be the case that the question, I want to know who holds my note, be a legal question?
I didn't say it was a legal question. I said we would refer them to an attorney if they had legal questions.
Right, but the question I pose to you in that hypothetical is, I want to know who holds my note right now.
And we should be able to tell them who we believe holds their note based on the documentation that we have.
Okay. And who would that be?
I don't know. You want to give me a specific example?
Well, let's look at Lucero. Let's look at her situation, because we're talking about her.
Right.
And
so
we can go back
in her
to
case, we have a beneficiary declaration that says Senlar holds the note.
Okay. And you would refer her back to the beneficiary declaration saying
Well, the beneficiary declaration isn't something that she has.
Okay. And so how would she know?
Object
Do you
to
know,
the
short
form.
of calling you and asking you and have you say, well, it's in the beneficiary declaration, and then you say, but you don't have that document. How would she know? How does she go about finding out that information?
Object to the form.
It's not a funding matter. Do you know what I'm saying? I mean, she has real concern about the information there which says Freddie Mac owns your loan. Sendlar is the servicer. Sendlar is the creditor to whom the debt is owed. And she doesn't really know, as you sit here, you don't know either. What is the difference between an actual holder versus a holder? And so the question I'm posing to you is not to be comical.
I'm not trying to be comical.
And the question is one of fact. It's not a legal conclusion. It's not for you to analyze. It's simply, if I want to know who holds my note amongst all these entities that are named in the notice of default, how do I do it?
Object to the form.
I don't know how to answer your question.
Do you don't know how to answer, or you don't have an answer at all?
Both.
So is it fair to say that within your company, there isn't really a place for the borrower to even know what the beneficiary declaration says
Object to the
at
form.
the point of them getting the notice of default?
Object to the
I
form.
don't know what one has to do with the other.
Well, when I get the notice of default, like in this case, Ms. McElligott, on this date, on August 27, 2012, or a couple of days thereafter, when my client came home and found this notice of default posted on her house, right? She reads it, as we did, and it says many different things, right? We went through that. Do you recall?
Yes.
Okay. So it says to her here that NW Trustee was acting as the duly authorized agent for Sendlar in sending her this. It also tells her that the loan servicer is Sendlar, right? Do you agree?
And the back page tells her it's Sendlar.
Well, the back page says the beneficiary or beneficiary's authorized agent, right? So Sendlar could be an authorized agent, the way it reads. Would you agree? I'm just asking you.
I'm just waiting for the question.
Okay, so my question again is that how does somebody know if they have a question of who holds the note at the point of getting the notice of default when they don't have access to the beneficiary declaration?
Well, you say they don't know.
So they don't know,
Object to the form.
right?
I don't know what they know.
Okay. But at the point of you setting out the notice of default, your testimony is that they don't have a copy of the beneficiary declaration.
But even if they did, it wouldn't mean anything to them. Wouldn't you agree?
Why not?
Why?
Why would that information not mean something to them?
Why would it? If they can't read this and know who the note holder is, how would that help them any?
Oh, I see. So if they're too dumb to understand, then they don't get any help.
Object to the form.
Is that what you're
Let me
saying?
I'd like to go off the record.
You don't get to go off the record. I am conducting.
I'd like to request
No, I
a
have a question
No,
pending.
she just answered your question.
There is no, you're not calling, you don't have the authority to go off the record. I am conducting the examination.
After we finish this question, I would like to take a break.
Okay, that's fine, that's fine. So let me go back and understand what you're telling me. At the time my client received the notice of default, which is Exhibit 3, she had no access to the beneficiary declaration that you have.
Correct.
Okay. And you're saying then that if she, my client, the borrower, received this Exhibit 3 and reads it and she can't understand it, it doesn't help her to have this information either. Is that what you're saying?
I'm saying it's no different than having this information.
Why is that though?
I don't know why that is.
Well, surely you do have some opinions because you made that statement. What is the basis for your statement? That it would
Why
help
does
them?
she want to know who the note holder is and how will that help her?
Because you just said that the person who holds the note is the person who has the power to foreclose. Is that what we've been talking about? Right? I mean, let's assume for a moment that my client is not completely ignorant and she gets winds of the fact that your company, through your lawyer, has made statements in court or arguments in court that, well, the person who holds the note is the person who has the power to foreclose. And she gets this. She has no idea who holds the note, and she wants to know. Are you saying to me then, you don't have any resources to give her? You have no directions to send her to? That's my question.
I guess my answer is then no, I don't.
All right. We can go off the record for 10 minutes?
Yeah.
Okay. You need 10 or you need more?
No, kind of.
Record reflect, we're going off now at 1:54. Is that right? Yeah. Awesome. May the record reflect it is now 2:06 p.m. and we're back on.
You've been given Exhibit 37, Ms. McElligott. Can you take a look and see if you recognize 37?
That's a notice of default generated by Northwest Trustee Services.
Okay. And I know that your name is not on this notice of default. Do you know who Kathy Taggart is?
Yes, I do.
All right. But I'm going to ask you some of the questions again in terms of the purpose of the notice of default to notify the borrower information related to their loan. I'm going to ask you to look at the exhibit and look at paragraph K under contact information for note owner and loan servicer. Please. Do you see that?
Yes,
Okay. Do you agree that the description of the note owner here is not a loan servicer or a GSA, a government sponsored entity, but a trust of some sort?
I have no idea.
You do not understand the concept of securitized trust,
I have,
do you?
I have had nothing to do with these types of loans.
Okay. But just bear with me. So this type of loan, here Northwest Trustee discloses who the owner of the note is. You see that?
I do.
And do you agree that below that information is the information for the servicer?
Object to the board.
I have no idea.
Does it say care of Select Portfolio Servicing Inc.?
Correct.
Right? And there's no phone number for the owner of the note listed there, is there?
There's not.
Okay. And if I direct you down to the bottom of the page where the date appears, do you see that?
Yes, I see that.
And do you see the reference that Northwest Trustee Services basically prepared this notice of default as duly authorized agent for Wells Fargo Bank NC as trustee on behalf of the certificate holders? Do you see that?
I do see that.
And then you look down further and you see that the client is being identified as Select Portfolio Servicing Inc. Do you see that?
I see that.
So between Wells Fargo Bank NC as trustee on behalf of the certificate holders and Select Portfolio Servicing Inc., who is Northwest Trustee's client,
Object to the board.
if you know?
I don't have that answer for you.
Who handles these loans? Do you know at Northwest Trustee? And when I say these loans, I'm talking about loans that are owned by a securitized trust.
Well, in this particular case, Kathy Taggart has this file.
been handed 39. Take a look at 39.
It's 38. Did I give you 2 38s?
It should be 39.
It's my 38.
Oh,
Okay, I'm sorry. No, it's my, no, you're right, you're right.
It's 38. Oh, sorry about that. Okay. So you're now looking at 38? Do you recognize 38?
As a notice of default issued by Northwest Trustee Services, yes.
And in this particular notice of default, Ms. McElligott, it has Heather Smith's name on it. Do you see that?
I do see that.
And it also referencing the owner to be another securitized trust. Would you agree?
Check to the form.
Paragraph K.
I don't have knowledge about a securitized trust.
To even identify it. Right?
Not, no, yeah, no.
Okay. Who does Fannie Mae loans at Northwest Trustee?
There are a couple of people who would handle Fannie Mae funds.
Do you know who they are?
Heather Smith, probably Nancy Lambert, Kathy Taggart.
Did I have anything else?
I have just very few questions. All right, so earlier you testified in regard to communications you may have with Freddie Mac. Do you recall that testimony?
Yes.
On a regular basis, do you communicate directly with Freddie Mac?
Not on a regular basis.
There have been circumstances where you've communicated with Freddie Mac, though?
Correct.
And what modes of communication would you typically use to communicate with Freddie Mac?
Sometimes phone calls, sometimes emails.
Is it your understanding, though, that Freddie Mac communicates through its servicer?
Yes.
And that's generally who you communicate with, the servicer?
Correct.
But if there was a circumstance that you needed specific information from Freddie Mac, you wouldn't be limited from contacting them?
No.
There was also some questioning regarding when we were talking about the beneficiary declaration in the Lucero matter, how or why that beneficiary declaration would have been produced. Do you recall that discussion? Do you recall the questioning about the beneficiary declaration in this case?
Yes.
And I believe that there was a question characterizing or stating that Northwest Trustee would have provided this beneficiary declaration in the context of mediation. Do you recall that?
No, actually.
Okay. So you also testified about Northwest Trustee Services' role in the mediation. Do you recall that?
That we don't have one.
Okay. And so would Northwest Trustee ever provide a beneficiary declaration to, say, the borrower or to the mediator for the purposes of mediation?
I'm assuming we would if we were asked to do so.
rephrase that. You testified that you might provide a copy of the beneficiary declaration per the request of the mediation council. Do you recall that testimony?
Yes.
Northwest trustee, though, would not provide a copy of the beneficiary declaration directly to the borrower or to the mediators for purposes of mediation. Is that correct?
No, it would go through the mediation process.
Because Northwest trustee has no role in mediation.
Correct.
That's all I have.
I want to follow up on your counsel's question about communications with Freddie Mac. Do you recall if you have any communications with Freddie Mac in the Lucero's file or foreclosure?
I don't recall.
Given the fact that you believe the holder of the Lucero's promissory note to be Senlar, do you remember that testimony?
Yes.
Do you know when they started holding the Lucero note?
No, I do not.
Do you know where they are holding the Lucero's note?
No, I do not.
Do you have any way of finding out the information that I just asked you?
I'm sure I could ask.
Who would you ask?
I would ask Sunmar.
Okay. I'm not clear in terms of the timing of your receipt of the beneficiary declaration in the Lucero case. Do you receive that declaration at the time of the referral, or how long after?
Object to the form.
You said specifically in the Lucero case?
Yes.
So we received it after the referral.
In general, how long after getting the referral would you get the beneficiary declaration?
There's no in general. Sorry.
And isn't it true that there are cases where you, Northwest trustee, actually prepares the beneficiary declaration,
Object to the form.
Periodically,
and you actually send it to the servicer for signing?
yes.
So under those circumstances, when you got the referral, you did not have the information of, you did not have the beneficiary declaration. Is that a safe assumption?
Yes.
Under what circumstances can the borrower request a beneficiary declaration from you without having to file a lawsuit or getting an attorney?
I don't know.
All right. That's all I have. Thank you very much.
The record reflect now is 2:18 and we're going off record.